The following program was produced by the United States Courts.
Criminal defense lawyers around the world work in different political and legal systems, but they have many shared experiences as defenders. Almost all face challenges of one kind or another to secure necessary funding and time, access to their clients, training, and other resources necessary for zealous and effective representation. So our second panel today will focus on what we can learn from each other as members of a larger worldwide defender community. And as part of that discussion, we'll also examine the structures and criminal justice systems in other countries to identify some practices that we might consider using here in the United States. And now I'm pleased to introduce our distinguished panel of experts to lead today's discussion. Betsy Andersen, at the far end of the table, is director of the American Bar Association Rule of Law Initiative, known affectionately as ROLI. She's an expert in international human rights law, international humanitarian law, and international criminal law, and teaches these subjects as adjunct professor at the American University Washington College of Law. Welcome, Betsy. To my immediate right, Tim Lynch leads CATO's Project on Criminal Justice and has become a leading voice in support of the Bill of Rights and civil liberties. Mr. Lynch's research interests include the war on terrorism, overcriminalization, the drug war, militarization of police tactics, and gun control. In 2000, he served on the National Committee to Prevent Wrongful Executions. And welcome, Tim.
Thank you.
And Ed Bostic is the federal public defender for the District of Delaware, and he was simultaneously the interim federal public defender for the District of the United States Virgin Islands from February 2012 through December 2013. From 1994 to 2006, Mr. Bostic served as an assistant federal public defender for the Federal Community Defender Office for the Eastern District of Pennsylvania and was the managing attorney of the Allentown branch. So welcome to all of our panelists. Thank you very much for being here. Let me begin with Tim. Tim, our common law system is historically based on England's legal system, but the process that is used in England to appoint counsel to defendants who cannot afford their own representation is very different from ours. Can you just spend a couple of minutes and tell us about England's system and your thoughts about the advantages or disadvantages of their method?
Sure. I should start off by saying that we could easily spend a full day exploring some of the similarities and differences between the American system and the English system, but I'll highlight what I think are some of the key differences. Is that better? The first difference is that here in the United States, the right to counsel has developed through case law at the Supreme Court, the Gideon decision that was discussed earlier, whereas in England, the right to counsel developed through legislation, especially through a 1949 law called the Legal Advice and Assistance Act. A second difference is here in the United States, there is a means test to determine if somebody is eligible for legal assistance. So there's that test that the judge was talking about in the last panel where you have to file an affidavit to determine your assets, to determine if you're eligible. Whereas in England, there is no means test. Everybody is eligible for legal assistance there. Here in the U.S., the right to counsel generally attaches after the initiation of adversarial judicial proceedings. But in England, lawyers for defendants are provided for in police custody. There are lawyers in the police station, and they are available to render advice before there are any charges. Another difference is here in the United States, the primary responsibility for financing legal assistance has fallen on state and county government, whereas in England, the primary responsibility is with the central government. The fifth difference concerns the overall level of funding. England spends much more than the United States on legal assistance, even when you take into account the population differences. They spend a lot more than the United States. And the final difference concerns choice of counsel, how counsel is selected. Here in the United States, the affluent and the middle class can select their own counsel, but for the indigent, they have no say in the attorneys that are assigned to their case. Here in the United States, the assignment of counsel is vested in the court's discretion. In England, legal assistance is overwhelmingly provided by private counsel, and the defendants there select their own attorneys, the attorneys that they prefer. Now, over the past 10 years, England has been experimenting with creating some American-style public defender offices, but even in those jurisdictions, the defendants still select counsel. They can choose to go with the public defender, or they can choose private counsel. Now, one of the most interesting developments, I think, on the American scene is that we've never tried this choice of counsel system until very recently. There is a county now in Texas near San Antonio, Comal County, where a pilot program is now underway, where they're going to give this aspect of the English system a try in America, where they're going to give defendants the option of choosing their own private counsel. And the proponents of this system say that there are two advantages to this model. The first one is they say it will improve the attorney-client relationship. I think many of the people in this room have a shared experience, if you've been a public defender, where there's some mistrust early in the relationship because many defendants feel that they're just being processed through the system. You know, when somebody is assigned to them, it's somebody they don't know, they're not sure whether to trust them. A lot of them feel that they're just being processed by the system. Now that mistrust can be overcome by public defenders and assigned counsel, but it takes time. And we all know how busy everybody is, and a lot of people just don't have time to develop that trust. But with the choice system, they think that trust will develop much quicker. The second advantage to the client choice model is that it will align attorney incentives better with the interest of indigent clients. By this, they mean that the attorneys who are perceived to be doing a good job for their clients will get repeat business. So they will keep getting people coming to them and opting for their services, and so the attorneys that do a good job will expand and prosper. The indigent clients keep coming to their business, they can keep handling more of these clients, and they can hire an associate, so their practice will prosper and expand. The attorneys who are perceived to be doing a bad job, the attorneys that just plead out cases, they will develop a very bad reputation, and the indigent clients will opt away from their practice, and they will eventually be weeded out. So that's what they mean by aligning attorney incentives with the interests of the client. The client always wants somebody who's very interested in their case and will be very aggressive in representing their interests. So these are the major differences between English and the American system, and why, and again, I think another interesting aspect of the Americans in Texas giving this idea of client choice a try. And after a year, then they're going to test the system and evaluate it, and if they think it's worthwhile, then they'll expand it to other Texas counties.
Mm-hmm. Thank you, Tim. And let me focus for Ed with the next question on that voucher system, because I think it's a kind of a fascinating concept. We don't have anything like it here, or at least we haven't until quite recently. But Ed, you're the defender. Does this make sense to you, or do you think this would be a disaster?
I think it would be a disaster. I've heard everyone who's spoken so far talk about the gold standard. And we have a combination of a federal defender system and well-qualified CJA attorneys representing federal criminal defendants who cannot afford to pay for counsel. We also have the support of DSO in terms of national training and other help that we may need from time to time. But if you create a voucher system, I expect that you'll have a lopsided system where a small group of lawyers with perhaps a good reputation to begin with get the bulk of the cases. In many of our districts, we have multi-defendant cases where you need additional lawyers other than those that get them every day. And one of the complaints that we hear from CJA lawyers all the time is they don't get enough cases to invest the time to stay abreast of all the changes in the federal criminal law or with sentencing. Additionally, there's so much institutional knowledge in the defender offices where you have the ability to go down the hallway and engage lawyers that have been doing it for a while. So I think we need to keep the system that we have right now. I think it's the gold standard, and I'm glad to hear that Great Britain is beginning to experiment with our system.
Tim, do you have any reaction?
Well, I think it's interesting, too. I think one of the benefits of our federal system is that different jurisdictions can try different things, then we learn what works well and what doesn't work well. And I thought it was very interesting that England is beginning to experiment with American-style public defenders. Now, they have turned to that system mainly because of budgetary reasons. They think they might be able to save money. So that's been the primary driver there. But I think it's also interesting that, that Texas is going to give this a try, and I think it'll be given a fair shot, and we'll see how it works. I would just remind everybody that it is working right now in England. It's also working in provinces in Canada, like Ontario. The attorneys there considered the client choice thing to be a strength of their system. And when there's high levels of client satisfaction there, they say, there have been surveys saying, like, if you needed the services of an attorney again, would you go back to the attorney that you used for, that you selected, the firm or the private counsel? And like 80% of the clients say that they would go back to the attorneys that they selected. So there's high levels of client satisfaction there.
If I may add one thing, Tim, you mentioned the fact that it will help funnel to attorneys who are doing the better job for their clients. I think we have a system now in most districts where, with the CJA panel and the committee that tends to select and stay abreast of what CJA lawyers are doing, we have the opportunity to weed off people from the panel who are not doing such a good job. And I think with every defender office, I know in my district, if there's a complaint about one of the lawyers, a judge thinks that he or she is not doing an adequate job, which I've never had, by the way, they'll let us know. So I think there are ways to also cover those issues that you just raised, and I think our system works very well.
Well, Tim, I hope in a year when you get some initial results from Texas, you'll write about it, so we can talk about it at a future symposium. Betsy, let me turn to you. The U.S. justice system is often described as one of the best in the world. I'm sure you hear that when you work in other countries. But we're also severely criticized for incarcerating the largest number of people in the world. Many countries, for example, have abandoned the use of life without parole sentences, but here in the United States there are thousands of prisoners serving life without parole sentences, several thousand of which were sentenced for nonviolent crimes. So can you talk a little bit about how the U.S. compares to other countries in terms of its sentencing policies?
Sure. And I should qualify my remarks in that the countries that I'm going to refer to and describe are the countries where ABA Rowley is working. So by definition, they tend to be countries where we see real needs for criminal justice reform. They're not necessarily going to be the gold standard countries. But even in that context, you're absolutely right that the United States takes the prize for the most and often longest incarceration by far. And not to mention also collateral consequences of conviction. 5 times more are detained in the United States than in other developed countries. More people are incarcerated in the United States than in China and in Iran. And the ABA and its partners in its collateral consequences project has documented 45,000 laws that impose collateral consequences.
In the United States?
In the United States,
wow.
Yes. So, and you can see those in a very cool website called abacollateralconsequences.org, where there's a map and you can click on it and see all the
No advertising during this session, please.
Sorry. I like maps. But I have to say, notwithstanding that record here in the United States, we also, in the countries where ABA Rowley is working, see really serious problems with over-incarceration. In particular, real problems with pretrial detention, and that's related to a lot of systemic defects in the criminal justice system that we are working to address. We also see real problems with the lack of viable alternatives to detention, and there look for models from the United States and elsewhere that we can adopt. Many countries are overhauling, where we're working, are overhauling their criminal procedure codes to introduce adversarial processes. And unfortunately, there's often a rush to implement those changes before there's the capacity of the prosecutors, the defense, the judges to administer those new procedures. And the defendants are the ones who suffer, languish long in pretrial detention, often then to have a botched case abandoned. So there are real systemic problems there. We also see the overuse of detention as an automatic default in sometimes I would say political or legal circumstances that are challenging for a government, and when they're under criticism for being soft on crime, rounding up the suspects.
That sounds familiar.
Yes. And then folks are in pretrial detention, then often cases are dropped or settled for time served. So these kinds of systemic issues are a real problem that we see in many jurisdictions. A well-resourced system of post-conviction or post-plea alternatives to incarceration like probation is something that we also look to import from the United States elsewhere. A final problem that we see is that judges don't, related to incarceration is that judges often don't have the resources to evaluate sentencing. And we have undertaken some programs to support judges in providing social service or criminological support to evaluate cases and evaluate sentencing options in those contexts, but there's much, much more to be done in that regard. And again, lessons that could be learned here in the United States. And finally, we have in a number of places in Macedonia and Georgia begun to look at sentencing guidelines in kind of non-binding sentencing guidelines as maybe an important check on abuse and inconsistency and corruption that we see relating to sentencing. So yes, the U.S. has challenges, but there are certainly very significant challenges in relation to incarceration rates in other places as well.
Tim, you have a point?
Just in addition to those good points that were made, there's another aspect of the American system that you don't find in other countries, and that's has to do with our doctrine of dual sovereignty and the Supreme Court upholding successive prosecutions between state and federal prosecutors. There's so much overlapping law these days, especially in the drug area. The same underlying conduct violates both state criminal law and federal criminal law. And so prosecutors are able to exert enormous pressure on people to plead guilty by threatening to say they'll call up their friend in the U.S. Attorney's Office. And if we happen to lose at trial, you'll be prosecuted again, and you'll be looking at even more jail time. So this is something you don't find in other countries where you have this second threat underlying or overhanging the entire process, and I think that's very problematic.
There's so many good points here, it's hard to choose, but I want to pick up on one thing that you mentioned earlier so we don't lose this, the collateral consequences. It's such an important issue, I think, to discuss. And Ed, can you just talk a little bit about how the collateral consequences, 45,000, is that what you said, Betsy?
Yeah.
45,000 collateral consequences. How does it affect your relationship with your client? How does it affect the advice that you can give her?
Often you find yourself in a situation where, to go off of something that Tim said as well, where your client is facing mandatory potential charges, and you have a prosecutor who tells you, well, now is the time to come to the table, I need someone to cooperate, and you've just met the client. And you have to go talk to a client about making difficult choices. And you have a very limited time to do that in, because you need to get that person to the table if there's that opportunity and if the person is willing before the co-defendant or someone else takes hold of that opportunity. And it becomes very problematic because in any relationship, attorney-client, there is a factor of trust, and you need the opportunity to develop that trust in a relationship, and sometimes you don't have it. Other times, you're just faced with a situation where there may not be the opportunity to cooperate, but you're faced with the chance of negotiating a non-mandatory sentence, but you have a client who wants to go to trial, who would prefer to go to trial, but the risks involved are so high that you find yourself counseling the client as to, well, perhaps this is not the case where you want to exercise that right. I think it's about 97% of all federal prosecutions end up with a guilty plea. And they end up with a guilty plea primarily because the risks of taking the case to trial become so high. You know, ordinarily you hear folk talk about the federal prosecutors not bringing the case that they don't believe they can win. And so it's very difficult to overcome that. That's not to say that we do not try cases and that we do not win cases, but you have to be able to develop the relationship with your client to help him or her make better choices than what's necessarily available on the table.
Mm-hmm. Thank you. And Tim, you mentioned the plea bargaining, the pressure that is really infecting many of the relationships and the decision-making in these contexts. Can you talk a little bit more about that? And your work in overcriminalization does include study of those issues?
Yeah, absolutely. We do a lot of work on overcriminalization at CATO. I know there's a lot of good work being done by others on the amount of people that are being locked up and the mass incarceration and that sort of thing. That's what we call at the end of the system, but I don't think you're really ever going to get at the root of the problem unless we address the front end of the system, and that's how many criminal laws we have on the books, subjecting so many people to criminal sanctions. And a lot of people think I exaggerate on this issue of overcriminalization, but let me give you two very quick examples. There was a telling moment, I think, before the Supreme Court a few years ago when an attorney from the Solicitor General's office was explaining the scope of what he thought was the scope of a federal criminal statute called the Honest Services Statute. And he was explaining the government's interpretation, and he was interrupted by one of the justices, Justice Breyer, and he said, wait a second. Under your interpretation, I think we have about 200 million Americans in the workplace, and under your definition of this honest services fraud statute, I think 150 million Americans would fall on the wrong side of the line. And the attorney for the government, he kind of hemmed and hawed, but he didn't really deny the point. He just kind of fell back on, well, Mr. Justice, you know, we'll exercise our power in a very responsible fashion, you know, that old line. But just think about that for a moment, if this is what the representative of the government said. In the eyes of the law, 150 million Americans could be in violation of federal criminal law. And another case just from last week, you heard about Barry Bonds, the baseball player. The charges were threw out against him last week. I really recommend that you go look at that ruling. Let me just read a portion of it to you. The charge that was thrown out was an obstruction of justice charge. And a lot of the justices on the Ninth Circuit, they came to an agreement that in this case that charge should be thrown out, but they kind of disagreed on the reason. So we had a lot of concurring opinions in that case. Listen to this. I mean, they're talking about Section 1503 of Title 18, which is the obstruction charge. And this is Judge Kaczynski, joined by 4 other judges out there. He says 1503's coverage is vast. By its literal terms, it applies to all stages of the criminal and civil justice process, not just to conduct in the courtroom. It arguably covers conduct in anticipation of a civil or criminal case. Stretched to its limits, it poses significant hazard for everyone involved in the system of justice because so much of what the adversary process is about could be called or construed as obstruction. He says lawyers face the most pervasive threat under this regime, making everyone who participates in our justice system a potential criminal defendant for conduct that is nothing more than the ordinary tug and pull of litigation risks chilling zealous advocacy. He says it gives prosecutors the immense and unreviewable power to reward friends and punish enemies by prosecuting the latter and giving the former a pass. And he said those representing criminal defendants are especially vulnerable to these charges. So this is what we mean about stretching the meaning of these statutes to cover broad ranges of conduct. And I've just talked about two, honest services and this obstruction. There are thousands of other federal criminal laws on the books, and then you add that to the state and local rules. This is what we mean by overcriminalization. It's a very serious problem for our society, because when you think about it, what good are these great procedural protections that we talk about? You know, the due process, the right to an impartial jury trial, the right to counsel. What good are these protections if the underlying criminal conduct, if the net is so vast that it catches people? There's not much an attorney or a jury can do for you if they can show that you're on the wrong side of the line, right? So that's why we put a lot of work into it.
I'm going to come back to you in a minute with maybe some suggestions for how that can change. But Ed, Betsy, does this resonate with you? Ed, it must resonate with you on some level.
Absolutely. Yeah. It's difficult at times to understand how one person is charged and another's not, in terms of the discretion that the prosecutors have. But we are reactionary, and we're there to defend everyone that we are appointed to. The ability to negotiate at times, these cases are totally taken away from our hands, because you have a prosecutor who is set fast on pushing the case, and as I said, it becomes difficult for an individual to necessarily run the risk of incarceration after conviction. I would find it concerning if we were not allowed better opportunity to negotiate these cases. As I said earlier on, it is everything moves so quickly for a defendant where he's faced with the dire consequences of a plea versus a trial where he expects to exonerate himself.
Betsy, any thoughts?
No, I have to agree with my panelists, and I guess in my experience, here the U.S. stands out again with particularly broad-reaching criminal codes, and compared to many of the countries where we work, where there just aren't as many laws on the books, and the issues that we deal with more are misapplication of the law by prosecutors and counsel who are just not capable, trained, effective in their work, and so that's a different kind of problem.
Right, right. Tim, any suggestions for how we can address this?
Well, the overcriminalization is a real problem, but I've worked with a lot of people around D.C., Paul Larkin with Heritage, I don't know if he's still here, but they do a lot of work on overcriminalization as well. There seems to be a lot of consensus, all across the political spectrum, that this is a serious problem that needs to be addressed. But getting the lawmakers to, take an interest and try to scale this stuff back is very difficult. There have been some hearings by the crime subcommittees on the House side. There's been some agreement between Sensenbrenner and Bobby Scott and some of these people. So we're beginning to see maybe the very beginnings of interest in reforming this. But are we going to see dramatic changes sometime soon? Probably not. Probably not.
Okay. Let me change tacks a little bit and talk about structures. So we know the CJA provides us with a structure and a mechanism to deliver legal representation. Other countries appoint counsel, but they don't have established systems the way that we do. And it's interesting that although a number of human rights instruments enshrine the right to counsel, really, and will defend it in every way. There's no requirement to create a dedicated public defender system that will deliver those services. So I want to start with Ed and then go to Betsy. Ed, what do you think are the advantages of having a dedicated system like the one in the U.S.?
Well, one, as I said earlier, is the institutional knowledge that is developed within the Federal Defender's Office or with well-seasoned CJA counsel who've been handling a lot of federal criminal cases. We have national training through DSO and with individual offices where we have continuing legal education, hands-on, whether the sentencing or litigation in the courtroom. And that is of great benefit. Also, we have the situation where you have an individual who knows the lay of the land. He knows the prosecutor. He knows the judge in front of whom he or she is appearing. And may have worked with probation officers in the past on different aspects of mitigation. And I think a lot of that is lost where if you were to disband the system that we have now with a combination of federal defenders' offices and CJA counsel panel members.
Mm-hmm. And Betsy, what have other countries done in this regard?
Well, in this, at least compared to the countries where ABA Rowley is working, this is not the UK, the well-resourced, UK system, but most of the countries where we're working do not have an established public defender system. There are only 2 countries where we currently have operations that have that in place, and we've worked closely with the governments to establish that in Armenia and Ukraine. Even there, they're much more rudimentary than our system, don't have the same resources, don't have the same level of training for defenders. In most countries, it's appointed counsel from lists that are maintained by the bar with varying checks on quality and licensing and that sort of thing.
Sounds like the situation before the Criminal Justice Act here in the United States. Yeah.
Exactly. That's really where we are. Run the clock back 50 years, and we can see all the problems with that earlier situation here, including inadequate assistance of counsel, under-resourced counsel, lack of services, expert and the like for counsel, lots of corruption, the so-called pocket counsel who are in the pocket of the judge and appointed case after case. So I can't recommend that we roll the clock back. In fact, we're looking to import more of the U.S. model in many of these places.
Well, and you mentioned politics, so let me talk about that with my next question. I think criminal justice, we could all agree, is sort of inherently political, not only here in the United States, but in many countries. But here in the U.S., elected officials are making many of the critical decisions in state and federal government, critical decisions about charging offenses, sentencing policies, attorneys' fees, and funding, elected officials. How unique is that compared to the rest of the world?
Well, on paper, it is quite unique, I would say. Most of the places where we work have, at least in principle, a structure for appointment of an independent structure, independent of the government, of the Ministry of Justice, for appointment of judges and prosecutors. And usually the members of that council, that independent council, will be designated by the one from the court, one from the ministry, one from the Bar Association, and then a number of others who are appointed or elected by the council itself, independently. But that's in principle. In practice, politics invades those appointments and often invades the work of those councils in turn in appointing judges and prosecutors.
But I do think we're probably the only country in the world that elects its judges. Is that true, in your opinion?
In my experience, I haven't
you haven't taken a full survey of the entire world?
200 countries, but yes.
Tim, what are your observations about the effect of politics on the criminal justice system, and how does it affect the stakeholders in the system?
Yeah, I think this problem of electing judges is a real one, and like I said, I would like to see more jurisdictions experiment with other methods. You know, I don't know if Texas is ready to stop its system of electing judges, but I'd like to see other jurisdictions, you know, move to more appointments, and then again we can compare and contrast. I know the other panel was discussing about like whether the public defender office should be attached to the judiciary or lodged somewhere else. I know some public defenders like Jeff Adachi is an elected official in San Francisco. I don't know if any work has been done to whether conclusions have been reached, like whether that's a superior model or whether appointments are the way to go. But when I haven't studied something very closely, I fall back on this. Gosh, it would be good to have different jurisdictions try different things, and then we can look at the evidence and the experience, and we can benefit from that.
Mm-hmm. Thank you. Ed, let's talk about funding and fees, equality of arms. When I've talked to defenders in other countries, I often hear them talk about their struggles for sufficient fees and funding. And of course, we have an adversary system here in the United States, so we often hear about the need for both parties to be equally funded and resourced to achieve this equality of arms. But my question to you, Ed, is how real is that? Is there parity, and why do you give us your answer?
There is the notion that federal defenders are on parity with the U.S. attorneys in terms of their pay scale. However, I think all can agree that the U.S. Attorney's Office has way more resources, all the resources of the federal government. We, as Defense Counsel in the Federal Defender's Office, have been lucky to the extent that we have a budget and we can try to allocate fundings as we need to for experts. So we make decisions about when we hire an expert in any given case. CJA counsel is not that lucky, so to speak. They have to file a petition, and you heard this before, application with the court to appoint counsel. I was at a meeting not too long ago in February where there was a discussion about how often does CJA counsel file a petition for mitigation services at sentencing or for an expert. And it was very, very low. It was close to less than 5%, if I remember correctly. And that's because you have a CJA counsel being concerned that a judge may think, well, you don't necessarily need this. If you keep asking for this, then maybe you get bumped off of the from the CJA panel. But I heard Judge Blake talked about predictability and other aspects of funding and what it goes in for the legislature to fund defender offices in the CJA panel. We just went through a work measurement study, and one of the things that I think will be revealed is that federal defenders and the bulk, if not all, of CJA lawyers really have a calling for the work they do. They work time and time again beyond 10 hours, 12 hours a day. And I think if you were to do a study with defenders, particularly because I know many of them, you'll find that there's take less vacation than any other members of the I shouldn't say judiciary, professional period. And I think that's a reflection of the commitment. And in spite of the need sometimes for better or more funding, we do what we have to do to put forth the best case. And I think that's recognized in the end result, to hear others say that we are the gold standard. And when I say we, I'm talking about federal defenders, I'm talking about CJA counsel. Nobody can sit at a table or in a room with Tony Amsterdam and not know that he's at the top of his game.
Right.
Or with Terry and know that you're talking about excellence in terms of CJA and federal defense litigation.
Thank you, Ed. Betsy, how do other countries fund their systems?
Inadequately, unfortunately, in most of the places that we work. But I would say, actually, that is not the worst challenge that we see in terms of equality of arms. I think the bigger problem that we see is really a cultural problem, particularly in jurisdictions where there's a transition from a traditionally inquisitorial civil law system to a adversarial system. And it's just very difficult. I think it's a generational change, ultimately. It's very difficult to change the habits of prosecutors and judges in particular from that inquisitorial process when they were working hand in glove to an adversarial process. And so there is rampant ex parte, communications between prosecutor and judge. Judges not appreciating the role of defense counsel. I was just in Serbia and heard an account of a defense counsel who was dismissed and disciplined by a judge for objecting in the proceedings. And so there are real challenges there, and driving us in many places to really look to the next generation, focus our efforts on legal education and developing an appreciation for an adversarial process with the next generation of lawyers.
Yeah, I've done a little bit of training overseas, and I've also observed the same problem from the other side of the coin, which is that defenders often feel uncomfortable being the zealous advocates that we say they should be. And what we know that will work best for the system and for their clients, but they're very uncomfortable with being so aggressive with the court. And so I think that, again, is a cultural thing to get past.
Yes,
yeah.
And I should say it's often that situation is exacerbated by the structures and the training programs. So there are often joint institutes for training judges and prosecutors together. So they're being educated together, and those are structures that made sense in the inquisitorial system and then haven't been broken down. So they come into the process as friends and cohorts. And
But is there a trend moving away from inquisitorial to an adversarial system in many of the countries you work?
Dramatic.
Yeah, dramatic.
Probably, we work in 60 countries around the world, and probably 20 of them we're working on some aspect of implementation of a new adversarial criminal procedure code.
Interesting.
It is a really marked shift in criminal justice worldwide.
Okay, thank you. And one last question before we turn to our audience, but this is for all the panelists. Can you each identify a practice from another country that you'd like to see the U.S. adopt, and one practice of ours you think should be exported to other countries? I'll start with Tim.
As far as like exporting an idea, I'm a big advocate of jury trials. I'm very concerned about the decline of jury trials in this country, and I think it's a fantastic institution that a jury of lay people stands between the accused and the government that says he should be, deprived of his liberty and put in prison. So I think it's a real fundamental, important institution. I fight for it here in the United States, and I would like to see it moved and embraced by more countries. I did some, last time I looked, there was like countries like Canada, you don't get a jury trial unless you're facing like more than 5 years in prison. And in France, it has to be like something like 15 years if you're going to get a jury trial. And then they combine it, a jury trial of, there's a trend underway to, when they call it jury trial, it's lay people and sometimes some judges or some other professional people. On paper, the jury trial exists in Russia, but they get around it all the time. It's very rare for it to be in that country. So that's something I would like to see embraced by other countries. As far as like importing an idea from overseas, like I've talked about 2 ideas from England. They have a bigger commitment to legal assistance than the U.S. I'd like to see that here. Obviously, a lot of the people here have been fighting for that for some time. But I'm also a big proponent of this choice of counsel idea that I mentioned earlier. And I'm excited that Texas is going to give it a try. And again, I think we'll benefit from that experience and learn to see how it works. Just to briefly respond to Ed, these are not, the attorneys who are taking these cases, they're not aliens that come in from other places. They're used to work for the public defender's office. So they've got a lot of that institutional knowledge. They've decided, to hang out their own shingle. And sometimes, there are aggressive people who work in the public defender's office, who fight maybe too hard, want to take too many cases to trial, where the boss has to sit them down and say, we've got to also move cases. So they've kind of got this divided loyalty. They've got a lot of commitment to the indigent, but they've also got, these budgetary concerns where the appointed and assigned counsel also have to be mindful of whether the judge and the court are going to select them again. They've got to please their public defender boss who may think that they're taking too many cases to trial. So a lot of these people want to break out and hang out their own shingle. And if they are doing a good job, again, clients will flock to their office. And for these people who plead out a lot of cases, they will not get the business. So I think it's an interesting thing, and I'm excited about it.
Mm-hmm. Thank you. You're going to answer
Yes.
Tim, aren't you? Instead of answering my question, you're going to answer Tim. Okay.
There's no federal defender's office in the nation that will say to any of its attorneys, you're taking too many cases to trial, we got to move cases along. It just wouldn't happen.
Well, would you agree that it's not unheard of in public defender offices at the local level?
To the extent that there are some state public defender's offices that are woefully underfunded, and unfortunately, you have an attorney who may be handling 60 cases on a list in a given day, you may have problems like that. But if you're making a comparison to the federal defender's national system and the CJA system that we have, that's not going to happen. Whether it be CJA or a federal defender, assistant federal defender, they're not going to take on more than they can chew, and they'll say to the judge, I need to push this back, but this client in front of me is getting the best representation that money cannot buy because they're all underpaid. Mm-hmm. So I just want to say that about the voucher system, and it may work in Texas, and I don't know if there's anybody here from Texas, but I think that nationally what we have works very well, and I would hate to see anyone begin to mess with it. I think that Judge Blake, and she may remember my name because during the sequestration period, we had a situation where, coming out of it, we were in dire need of assistance and additional attorneys. And with the help with DSO and going through Judge Blake's committee, we were able to get funding to do that. So don't fix it if it's not broken, and I don't think it's broken. I heard Terry said, I heard Tony mention, and Judge Blake, there may be tinkering around the edges, and we are willing to do that. I think the work measurement study shows how we're willing to work to get the best product and to get the best resources and have predictability and work on cost containment.
Mm-hmm. I see a great law review article with you two as authors in your futures to hash this out for all of us to say. But let's get back to the question, if you would, Ed. What would you export and what would you import?
One of the things I would export, and I think Betsy talked about this a bit, is we have such a wonderful system of continuing legal education for federal defenders and CJA counsel, both nationally and locally. I had the opportunity today to say to Terry, when are you going to come to Delaware and put on a seminar for my CJA and my attorneys? And that's because he's available and willing to do that. When I was in the Virgin Islands and we needed to put together CLE programs where they were in dire need of it, I reached out to DSO and we got together a panel that was just totally excellent. And we did it a couple of times. So I would like to see us export that in terms of the notion that not only the judges and the prosecutors get this training, but the defense attorneys as well.
Sure. Good. Anything you want to import?
Yes. I think the attorney from Oregon, right? I think that talked about
Judge Aiken.
Chief Judge, my apologies. I didn't recognize you at all.
Because I want you to know that this, I'm
And I apologize for that. I did not recognize you. But one of the things that is really important is the notion of moving towards a more rehabilitative aspect to sentencing and punishment, and away from the punitive aspects. And I know a lot of the European countries approach punishment and sentencing a little different, where there's more mitigation, they're looking at more factors, and where education and resocialization is a major part of the prison system. You get it in the system. You get it with the guards. They're not only carrying a baton, but they're carrying knowledge about how can I help this person find a course or education or some type of vocation. And it goes from restrictive to less restrictive depending on how the person is progressing. We have smaller prisons that are located more in the heart of the community, where the defendant, the sentenced prisoner, is committed his crime and where his family lives, so that he or she can have better support mechanism, and they work collectively together to help reintegrate that person back into society. It is not about 20 years. It's more about enough time to help rehabilitate the person so that person can become a productive member of society. It's not about taking away his or her rights to vote after conviction.
Right. Thank you. Thank you. Betsy?
So to export, you can tell there's lots that I think that we can export, certainly to the countries where I'm working, though of course there's no kind of transplanting exactly or cookie cutter approach, but I do think the standing, defender service and professional defender service is definitely something, a structure that we could stand to export to a number of places where we're working. In terms of bringing something here to the U.S. from the countries where ABA Rowley is operating, it's not, again, a direct kind of import, but maybe some lessons to be learned from the educational process for judges and prosecutors in many of these countries. And it's a different legal education system too, of course. Many of these places, you get your law degree as an undergraduate degree, and then there's a track for those who are going to become judges and prosecutors. And as I said, I think they should be separate, but there's something to be said for that professional, usually a 2-year specific training for judges and prosecutors before you ever have a case.
Interesting.
And I think that there is something to be said for that kind of program.
Thank you. We have a few minutes left for questions. I hope there are some. Yes, please. The microphone is coming.
Sorry I missed the first panel. My name's Elaine Middleman. I do CJA work. And so I don't know if this is really on point here, but just in general, there's no right to counsel for 2255s. And there seems, in my experience, has been a lot of important issues that have to be brought in that context. And it's laughable because you have the jailhouse lawyers, and I think they even charge people inside the prisons claiming they're going to give them some great deal or something on the 2255s. I mean, it's a racket. And on the other side, you have the U.S. Attorney's Office. And if there's important legal issues there, clearly they're not briefed properly. And so it leaves the judge, I think, floundering. And I just don't understand why that is allowed to persist. And I've had specific cases where that was an issue. So
Right. So we're talking about parity of resources again and provision of counsel.
There is there is no resources for.
Right. Ed.
I believe a lot of defender offices, I know my offices, have approached their district court chief judge about appointing us to non-capital habeas cases, and we've had a favorable response to that. At the end of the day, it may very well come down to resources in terms of what any given court is willing to do, but I'm very happy to say that my chief judge has responded well, and I think we'll be taking on some of that 2255 work.
Right. And there are a number of lawyers in the federal system who are dedicated to representing defendants, in the 2255 provision, so proceeding. Other questions? All right. Well, any concluding remarks from our panelists?
Well, one of the questions we talked about was prospects for significant reform to our criminal justice system. We didn't really get to that, but since we
Sure.
don't have any a question, I would say that I'm a little pessimistic on the federal level as far as like significant sentencing reform, but I think two things I am optimistic about, and one is because of the events over the past few months since Ferguson. I think the idea of revisiting police misconduct and how that is handled is really up for discussion now. Like it's never been before, or at least in a long time. So I see good prospects for changes there. And secondly, there's a marijuana arrest in this country once every minute, 24/7, all year long. And to me, it's a gross misallocation of resources of attorneys, courts, probation officers, and prisons. So the biggest thing happening is these states that are moving away from the criminal law approach: Colorado, Washington, Alaska, and Oregon. So that's the big change that's coming along. And California and Nevada are expected to have referendums in 2016, and that's going to bring big changes. And so those are the bright spots in my view.
Mm-hmm. Anything to add?
Just to follow up on what Tim mentioned about sentencing reform, and what I can say is that, and I don't know if it's coming to the federal system or not, but since Booker, we've had the opportunity to really benefit or have our clients benefit from substantial mitigation at sentencing. The judges now have free ability to go outside the guidelines and sentence a defendant as the court finds that person is necessary for that person's rehabilitation and punishment. And that means that in order to do the best for our clients, we really have to put on a strong mitigation at the time of sentencing. That means CJA counsel has to have the resources available to hire the psychologists or other experts to explain the mental health problem that may have contributed to the crime. And hopefully we can get the judge to see that the defendant standing in front of them needs more than just incarceration, perhaps alternative to incarceration, perhaps better mental health care, perhaps good drug counseling. And I think we have that opportunity, and I know that most of us are not squandering it, and I know that there's a large part of the judiciary out there that is waiting for us to bring it to them. And so I would encourage everyone in the room that is a defender or a CJA lawyer to make certain that we do that.
Excellent. Betsy, anything?
Well, I just really want to reflect on the anniversary and how important and this act is, and this principle, and the work that the people in this room are committed to doing. I was just in Ukraine a couple of weeks ago, and I did a radio interview, and they asked me about Gideon versus Wainwright. And I just thought that was amazing that a radio interviewer in Kiev would know that case. And I think sometimes we take it for granted, and I just want to commend the organizers of this conference for not doing that, for continuing to focus our attention on these issues, for thinking about how we can continue to perfect this work. And I really want to thank you all for that and for the opportunity to be here.
Well, that's a lovely note to end on. So, audience, will you please help me thank our panelists? And thanks to all of you.